Good afternoon, everyone, and welcome. Thank you again for joining us today in our the first 100 days employment law looking ahead. At this time, I'm going to turn the webinar over to Nancy Elliott, one of our in-house counsel, as she will be our moderator for today's webinar. Nancy?
Thank you, Donna. Good afternoon, everyone. Welcome and thank you for taking the time to join us for our webcast today entitled The First 100 Days Employment Law in 2021, A Look Ahead. As Donna said, my name is Nancy Aaliyah and I'm an Associate General Counsel in BankUnited's Legal Department. On our panel today, I am pleased to be joined by Anne-Marie Estevez, Claire Fitzpatrick, and Jonathan Snare from the law firm Morgan Lewis and Bockius. Before we get started with the presentation, I'd like to go over a few housekeeping matters. Today's event is audio listen only, so questions will not be taken verbally. If you would like to ask a question to one of our guest speakers, please type your question into the chat feature and hit submit. We will try to answer as many questions as time permits. Now, with that out of the way, I'd like to turn the session over to Annie to get us started. Annie?
Hi, so we're just going to introduce ourselves first and then Claire will take it away. But as Nancy said, I'm Anne-Marie Estevez, or most people call me Annie. I'm a labor and employment attorney. I both counsel and I handle litigation matters as well as ADA public accessibility matters, like whether the blind have access to your internet sites, which hits a lot of people. I lead the industry retail group nationally as well for about 15 years. And I have, like Claire and Jonathan, become a COVID expert in this past year. I'm delighted to be here with two of my great colleagues. And with that, Jonathan, why don't you introduce yourself?
Sure. Good afternoon, everybody. I'm Jonathan Snare. Most people call me John. I am the head of the OSHA Workplace Safety Practice Group at Morgan Lewis. I've been at the firm going on about 12 years, but previously I was at the U.S. Labor Department in a number of roles, one of which was the acting assistant secretary for OSHA. I also was the deputy solicitor for about 2 or 3 years. So I'll be talking a little bit later about the Labor Department and bring you some insights about that. I'll turn it over to Claire.
Hi, thank you. I'm Claire Fitzpatrick. I'm a partner in Philadelphia in the Labor and Employment Group. A lot of my work traditionally focuses on discrimination cases and whistleblower investigations. As Annie mentioned, over the last year, a lot of my time has been spent counseling businesses on the many issues that COVID has presented, including whether to close a business or how to keep it open or how to reopen the business. So we're all very happy to be here today and look forward to talking to you about some of those issues as well as what's coming up within the new administration. If we could bring the PowerPoint up, we can get started. Great. All right, so maybe we pop ahead a couple slides. All right. We obviously can't cover everything that's going to happen in the next 100 days in employment in the next hour, but we will focus on some key issues that the agencies are working on, including health and safety, as John mentioned, especially in COVID-19. Annie will touch on some wage and hour issues, and we'll also talk about the EEOC and their focus on systemic discrimination, among other issues. But first, we want to provide a little context about the structure of both agencies and what we know about the current and expected leadership. Next slide. So as many of you probably know, the EEOC, the Equal Employment Opportunity Commission, is a bipartisan federal commission. Each commissioner is appointed by the president and confirmed by the Senate. They serve 5-year terms, and the general counsel serves a 4-year term. Each commissioner's term is fixed. And what that means is that there is only supposed to be 1 vacancy per year, regardless of which party is in charge. The statute also provides that the chair of the commission shall be of the same party as the president. As a result of these two things, we're in the unusual position right now where even though we're under the Biden administration and Charlotte Burrows is now the Democratic chair of the commission is still comprised of 3 Republicans and only 2 Democrats. The commission will not be a majority Democrat until either July 2022, when Janet Dillon's term ends, or sooner if one of the Republican commissioners decides to step down before their term actually expires. Despite that seeming imbalance of power, that doesn't mean that the chair is powerless. All of the offices at headquarters and in the field directly report to her. And she also controls the agency's budget. She has the power to set the agenda for commission meetings and to issue, through the Office of Legal Counsel, sub-regulatory guidance. For anything that requires a commission vote, however, whether that's a new regulation, an update to a compliance manual, or approval to file an amicus brief or certain other types of litigation, she will still need the vote of at least one Republican commissioner in order to get that done. One other note is that the previous general counsel, who had been appointed by President Trump, was removed from her position and was replaced by Gwen Reams, who is the current acting general counsel. She's actually been with the agency for 50 years, so she certainly is familiar with what the EEOC is doing. Next slide. Ultimately, the day-to-day work of the agency is not going to change significantly despite the change of administration. And the reason for that is because the day-to-day work, the investigations, the conciliation, and the litigation of charges is done by each of the 53 field offices throughout the country. Those offices are headed by 15 district directors, and each of them sets the tone of their individual office. Often there's this idea of focusing on operating as one EEOC, but there's also been and that sort of reflects this push to be more consistent throughout the agency. But ultimately, those district directors that run each of those offices hold a lot of power in setting that tone. Next slide. We wanted to quickly review the priorities from the EEOC Strategic Enforcement Plan. This plan was developed in 2018. And that was when the Democrats previously controlled the agency. And so we anticipate that it will be reinvigorated under Chair Burrows. It provides a good roadmap of the substantive areas that we believe the agency will focus on, especially in the beginning of the Biden administration. In particular, the first two here, eliminating barriers in recruitment and hiring. We expect the EEOC will focus on systemic barriers to recruitment and hiring, especially when it comes to the use of social media as a recruitment tool and artificial intelligence as a screening tool. We see that a lot in age discrimination cases and race and national origin discrimination cases. Given the administration's focus on racial equity, we would not be surprised if the EEOC also begins to focus on issues regarding implicit bias and systemic racism and how that impacts recruitment and hiring practices. The EEOC is also focused on protecting vulnerable workers, like migrant workers, and we anticipate that that will certainly be a renewed focus of the agency, given that this is a focus of the new administration. And it's definitely an area that the district offices care strongly about. Next slide. Then, in terms of some of the next strategic areas, it will be interesting to see how the agency identifies what are new emerging and developing issues, because this list that's here is from 2018. And so, we think that this is a little bit dated. It'll change as this administration begins to flex more of its priorities. We'll talk a little bit about equal pay as well, but we did want to flag here that equal pay has always been a huge priority for Chair Burrows. She worked on the Lilly Ledbetter Act, which some of you may be familiar with, that talks about prior discriminatory pay decisions, sometimes from long ago. And she was a huge proponent of the EEOC's pay data collection project, which is ongoing. So the other two, preserving access to the legal system will certainly be a priority. And we think that will come up when there are overly broad waivers in employment agreements. And that would be, things that you might want to worry about there would be no rehire clauses. That's something that the EEOC is very averse to, competition restrictions and confidentiality restrictions, non-disparagement restrictions. As it relates to preventing systemic harassment, this has always been a bipartisan priority of the commission, and we very much expect that to continue. We think that the change here we'll see would not just be on sexual harassment, which because of the Me Too movement has been a big focus over the last several years, but will now evolve to look more at racial harassment and the idea of intersectionality and harassment based on that intersectionality. We also note that on the day that Chair Burrows was appointed as chair, she made it a point of stressing that part of the EEOC's mission is to address the challenges of systemic discrimination. And because of that, we anticipate that the EEOC will focus a lot more on systemic discrimination because the EEOC believes that that is where it can have the biggest impact with its limited resources. Next slide. Okay, and then we just finally wanted to note that under the previous administration, the EEOC's new conciliation rules became effective. That was as of January 7th. And notably, Chair Burrows and Commissioner Samuels opposed that rule, but they did go through the full rulemaking process and become effective, which will make it more difficult for the EEOC to undo because of that. Under those rules, the EEOC now must provide employers with a lot more information regarding the conciliation process. It will be interesting to see if these rules lead to more successful conciliations or perhaps, as some plaintiffs' lawyers have suggested, will just lead to further delay. Under the final rule, the EEOC now must provide employers with the following information. A written summary of the facts and non-privileged information that the EEOC relied upon when it reached a finding of reasonable cause, a written summary of the EEOC's legal basis for finding reasonable cause, the basis for any requested monetary or other relief, including the calculations underlying that initial conciliation proposal and an explanation thereof in writing, and whether the matter has been designated as systemic, class, or pattern or practice, and the basis of that delegation. And then employers will have 14 calendar days to respond to whatever the agency's initial conciliation proposal is. So that's a new area. And what we've noticed in the conciliation space is that sometimes the EEOC's proposal and demands seem to come out of nowhere. And so this is really designed to provide more transparency and I think theoretically to make them more tied to what actually is at issue in the matter. With that, I will turn it over to John to talk a little bit about some of the other issues that have come up.
Actually, turn it to Annie to cover federal contractor issues, and then I'll be covering the Labor Department.
Oh, gotcha.
Yep, you can just advance the slide. So it's very interesting. There's not a big change in the fact that when the federal government can't get things done on a private level, meaning against private companies, they tend to start to look to federal employees, I think in some ways, to grease the skids and make it easier to later pass legislation that would impact private employers and private companies. So some of the things that we've seen are all of these laws, the EEO 11246, 503, and VEBRAA are all prohibitions against discrimination for federal contractors. So those who enter into contracts with the government such that you fall within these laws. These laws are still on the books. They've been on the books for years, but there are provisions within them that the Trump administration rescinded. And one that was at the tail end of the Trump administration was diversity training. And what the Trump administration said and the executive order said is basically that anything that was divisive diversity training, basically you could not have that. So people were starting to look at, what does that really mean? What kind of, we're about to train, should we still train? Well, no one really needs to worry about that because that is definitely was rescinded right away by Biden. So if that training was in place, you could just go ahead and have your training. There was also a religious exemption rule that would exempt certain religious organizations out of certain rules. OFCCP has already stated that they intend to also rescind that rule. Some of the other things to watch is, that there's been a lot of talk about the $15 minimum wage, throughout the past couple of years, and it still has not happened. But what we think is going to happen is, because it hasn't happened in the legislation dealing with COVID relief for the country that is probably going to be imposed on federal contractors. So that's something to watch out for. Another thing to watch out for is the fair, pay, safe workplaces. We think that there's some resurrection of that, where we'd look at enhanced enforcement in that space, supplier diversity, and the Small Business Administration enforcement. There are diversity provisions and requirements for federal contractors that they have certain levels of diversity. And the Small Business Administration is going to, we believe, increase their enforcement in that space to start looking at that more. We also, you'll hear more about pay data and pay equity. This is something that they care about, getting this data and making sure that people are paid fairly and equally. EEO1s and FOIA requests and potential litigation stemming out of that. There have been many requests. OFCCP is the agency that is responsible for answering Freedom of Information Act requests regarding data, and they have received massive requests. And so you could, if you are a federal contractor, you could receive you could get notice from OFCCP that this data has been requested, that there's been a FOIA request to disclose the data that you've provided. Some companies are responding to this by just publishing their own data so that it's not getting a notice and then not knowing what's going to happen with it. They're not trying to hide it, so they're actually publishing their own. But we do think that there's going to be a lot of objections to that. OFCCP has massive amount of requests on their hands, so that should be interesting. And one of the last things to watch in this space particularly is arbitration agreements. The Biden administration doesn't seem to care much for arbitration agreements and appears to want to narrow those more or potentially prohibit arbitration agreements for certain claims. And who knows if it will go as far as a ban on arbitration agreements, but we do see that there's a lot of disfavor for forcing cases to arbitration rather than allowing them to be litigated in court. The next slide. So some other Department of Labor activity, the OSHA Whistleblower Protection Program. OSHA is very interesting in this respect, and I've never really figured out why, and so maybe we can ask Jonathan about it. But as I understand it, OSHA is over 24 different whistleblower programs, and some of them will sound familiar to you. The Dodd-Frank, Sarbanes-Oxley, there's a bunch of environmental ones out there. But now OSHA is responsible for also overseeing worker retaliation complaints filed under the Criminal Antitrust and Anti-Retaliation Act and the Anti-Money Laundering Act. And then finally, there's going to be a pullback on IRAPs and a creation of a new advisory committee on apprenticeships. And Jonathan, any comments on, before we go on there, any comments on the whistleblower protection program and
Sure,
how OSHA is going to possibly keep up with now the 24th?
That's a great question. And I used to get it a lot when I was at the Labor Department. And it's actually a challenge for OSHA. When I was there, the Sarbanes-Oxley was only 2 or 3 years old at the time. And the challenge for OSHA was hiring investigators who are not in the traditional safety or environmental space to understand the complex financial issues in Sarbanes-Oxley and now Dodd-Frank. The whole history of it is Congress just sort of turned on autopilot. Congress started giving OSHA whistleblower retaliation statutory jurisdiction for a lot of programs where the substantive statutory jurisdiction is in other agencies like the SEC or the Department of Energy and the environmental agencies and and the like, because OSHA had whistleblower going back to its own statute for safety, but Congress started giving it to OSHA, and now they have, as you said, Annie, about 24 programs that cuts across, I mean, the traditional retaliation in the safety space, in the environmental space, but also the business and the criminal antitrust, as you mentioned, the Anti-Laundering Act, and the big issue for OSHA is hiring appropriate people to handle those investigations. But I think that's going to continue because there's no other agency with the experience on anti-retaliation.
Go to the next slide.
Okay, I'm gonna just a little bit of overview for everybody on the webcast because I think it's sort of interesting. This is an organizational chart of the national office, and probably the Department of Labor has about 15,000 employees across the country. and maybe just under half are in Washington. But most of those are career people who are there from administration to administration. The key agency and the key players is the Secretary of Labor, the Deputy Secretary, the Solicitor, who's the General Counsel, who's the third ranking official at the department. And then there's the other agencies, as you can see on the org chart breakdown. The key agencies, probably the largest, are Wage and Hour and OSHA from an enforcement standpoint. But Annie also spent a lot of time talking about OFCCP that enforces all these requirements for federal contractors. That's part of the Labor Department. It's sort of an agency within DOL, and it coordinates a lot with the solicitor's office. And out in the field, for those on the call who may have interactions with the Labor Department, as Claire mentioned, similar to the EEOC, most of the day-to-day enforcement work, investigation work that you may have encountered is done in the regional and area offices. The main regional office applicable to Florida is in Atlanta for the Labor Department, but then there's all sorts of area offices for OSHA all over Florida, Wage and Hour and the like, that does the day-to-day enforcement. That doesn't change from the Trump administration to Biden or even to prior administrations. All of the policies and the initiatives that are directed by the presidential administration will have an impact ultimately, and those decisions are made here from the offices in the org chart. Let's go to the next slide. We can talk about that a little more. So in terms of the decision makers, we've got the Biden administration has a nominee for Secretary of Labor. As you can see from the slide, his name is Marty Walsh. He's currently the mayor of Boston. He's very close to President Biden. He's very tied into the labor movement, and they've made unions in the labor movement a big priority. And I think those interests of the labor unions will continue throughout once Marty Walsh is confirmed as labor secretary. That's going to happen any day now. I was actually thinking it might happen today and would be able to report it, but it has not happened yet. The Deputy Secretary of Labor, the nominee, as you can see on the slide, is Julie Sue. She is currently the head of the California Labor Department. I think it's called the Department of Industrial Relations. So she comes from California, which has on its own a very aggressive enforcement agency, is well known for that. So she will be, I think she has a congressional hearing sometime. It may have happened already this week, but she'll be confirmed within a few weeks, I suspect. And then there's the Solicitor of Labor. They don't have a nomination yet. And then the other agencies, the key agencies, Wage and Hour, OSHA, EBSA, there's no names mentioned yet to run those agencies, but those names will be important because their decisions will ultimately be reflected in investigations that could be impactful on everybody, a number of us on the call. The director of OFCCP, and Annie talked about the agency. The interesting thing about this, and it's important, Jenny Yang was a former chairman of the EEOC in the Obama administration. So she was brought over because the OFCCP does not require in that role to be a Senate confirmed position. So she's brought over, I think, to elevate the importance of OFCCP from an enforcement standpoint, as well as to coordinate with the EEOC on a lot of initiatives, because they have a similar mission, just OFCCP deals directly and focuses on federal contractors. And then the other point, we'll go to the next slide, is the big priority of the Biden administration is on COVID. That was a big topic, as you all recall, in the presidential election. It's been a big focus, as Annie and Claire mentioned, and of everybody's, our practice in advising clients on COVID-19. That is definitely a big issue with the Biden administration. And so let's talk a little bit about that, because I think it's important, and front and center of that is OSHA. So this is a little bit of an overview of what has happened. There was the Biden administration issued an executive order day after the inaugural, outlining a number of steps they're going to take on COVID through the Labor Department. And one is this employer guidance that was released on January 29th. And it's basically brings in and weaves in all of the guidance that OSHA had issued over the past year, but it's updated, and it also confirms the latest from the CDC and updates that as well. And we'll get into some more details in just a second, but part of it is, that employers need to implement their own COVID prevention program, essentially a hazard assessment infectious disease program. I suspect most of you on the webcast have already have some program similar to this. because a lot of employers have been very proactive on this over the course of the past year, but OSHA is re-emphasizing this to everybody, and it is under as a big priority under the Biden administration. They've also signaled and stated that an emergency temporary standard will be issued by OSHA. It was supposed to be issued this week on March 15th. It has not been. And I'll talk a little bit more about that in the next couple slides. They've also had stakeholder meetings on COVID, but let's go to the next slide. We'll talk about the guidance in a little more detail. So this is, as I mentioned, there was an executive order on January 21st to outline a number of steps that the Biden administration was highlighting as a big priority because, again, as I mentioned, COVID-19 enforcement is a huge priority of the Biden administration. They're taking aggressive action to sort of set themselves apart from the prior administration. And this is one example of what they're doing. And again, OSHA is the appropriate agency within the entire federal government to be focusing on these issues on COVID and workplace safety. So here is a little bit of a snapshot of what the guidance, and again, it's guidance, not a regulation, but that's coming. But the guidance basically is reminding employers, a lot of what employers are probably already doing, and be interested to hear from those on the webcast what you are doing. But the first major step that's recommended by OSHA is to conduct a hazard assessment. That's essentially an obligation or a step for the employer to take to evaluate their workplace. Every workplace is going to be different. An office setting will be different from a retail setting, different from a restaurant, different from a manufacturing setting. But basically to go through, conduct an assessment. Where is the risk of COVID-19, the issues of social distancing? What steps can you take to reduce the risk of the transmission of COVID-19? And then as part of that, the next sub-bullet there is the employer identifies appropriate control measures to limit the spread of COVID-19. So that's, again, as it says here, engineering controls, which is reconfiguring the workplace. And again, that can be in an office or a manufacturing setting. There's a lot of guidance, for example, on the OSHA's website already about reconfiguring an assembly line, a manufacturing setting to increase the distance between employers performing manufacturing operations to increase social distancing. Use of plexiglass between employees, and that can be done in a wide variety of work sites. I've seen it with clients, again, from an office to a retail, to a warehouse, et cetera. So the part of the control measures also are training. And this is mentioned here, educating the workforce, training the workforce on how to take appropriate steps to use, employ these methods, follow social distancing, use personal protective equipment and the like. This guidance also talks about that employers encourage, adopt policies that if you do have an employee who maybe have COVID-19 or is thought to have COVID-19, encourage them to stay home. What you don't want to do is force an employee to think they have to come to work if they have some of the symptoms. And this was a big issue early on in the pandemic last year about guiding employers on what steps to take to make sure that they keep those employees home who think they have it or were exposed to it. And that's still continuing, even though I think the pandemic is lessening a little. And then the other point, the last point here on the slide is implementing protections from retaliation. OSHA was clear even last year on identifying to employers, and they put out a press release on this in April last year saying employers should not retaliate against an employee who complains or raises an issue about COVID-19 and COVID-19 safety issues. This guidance here encourages employers to set up a hotline or some type of compliance process to facilitate and allow their employees to make a complaint. If they're nervous about it, if they're concerned about an issue at a particular work site, to give them a mechanism to raise a complaint and to identify it. And that's also going to be a big focus, I think, on enforcement by this administration. Let's go to the next slide. And a few more additional points on the on this guidance. And it's interesting on the face covering mask issue. They provide that in this guidance that that the face covering in a mask can protect the wearer as well as anybody that the person wearing the mask is with. Previously, the CDC had said the mask only protects those in the presence of somebody wearing it, but now they say the protection goes both ways. And so again, continuing to highlight the importance of masks and face coverings. continuing to highlight and making it as easy as possible for employers to provide COVID-19 vaccine. Again, that happens, some employers have the ability to get it. Some of it's happening from the different states. People are getting it individually, but OSHA here is trying to signal to employers, if you can take steps to provide a vaccine to your employees, you should, and to continue to employ the protective measures, even if you're half your workforce or a third of your workforce, or even if everybody is vaccinated, you still continue to employ these same practices to ensure that there's no further spread, particularly if there's exposures to third parties and customers and the like. And the same thing here under the testing prong, workers who have recovered after a positive test should only, if they develop new symptoms after their first positive test, they should continue to employ social distancing to ensure that there's no spread. And again, the other point I mentioned earlier, the anonymous employee reporting protect employees from retaliation. Okay, let's talk about several other initiatives here. One is the National Emphasis Enforcement Program that was just announced about a week ago on March 12th. And what a National Emphasis Program is, by way of background, is a national priority set in Washington by the decision makers at OSHA, but it has an impact across the country. And it basically it gives OSHA probable cause to go into any workplace under the targeted topic. I mean, there's been, like, for the past 25 years, there's been a national emphasis program on trenching, so in the construction space. So OSHA then has the probable cause to go to a work site and investigate a trenching issue. And so here, this is, again, it's a signal that this is a big priority of the Biden administration, and but they're going to be focusing on, again, it's going to be focusing on COVID-19 for the next year. And they encourage OSHA state plan states. There are, by way of background, about 20 states in the country that run their own OSHA program under some supervision and budget support from federal OSHA, and they're called state plan states. California, for example, is a state plan state and pretty aggressive independent OSHA program, but others include Washington State, Oregon, and Michigan, and the like. But federal OSHA will encourage, and typically in the past, most states will follow a national emphasis program. So this is, I believe, going to be followed everywhere. COVID-19 is an unusual, it's a once in a century pandemic. So I think all the states are going to pick this up, continue to enforce, and this is going to be a big priority for the next year. Let's go to the next slide. And in terms of where this national emphasis program is going to go, what does it mean for you? And again, what this program does is basically provides direction from federal OSHA to the regional offices to the area offices, and it sets up priorities of where OSHA inspectors should go and be deployed. And as you can see here, down sort of in the second and the third bullet, they're going to be focusing on fatalities. So if you've got a work site where there's an employee who unfortunately has passed away due to COVID, or again, they'll focus on other fatalities as well, then the OSHA is going to be coming into the work. And let's say it's that scenario where there is a fatality non-related to COVID. OSHA will come to your work site, but then they're going to also use the NEP to investigate COVID, which you've been doing on COVID. So that could be an issue out there. I think on the industries that have been considered essential or high hazard in the whole COVID pandemic, that's healthcare, and then, but it also is going to include, as you can see on the bottom bullet here, grocery stores, warehousing, storage facilities, restaurants, retail settings. A lot of these that have been open throughout, except for maybe the first couple months of the COVID outbreak last year, and their employees are on the front line dealing with customers and third parties. OSHA, and that's where OSHA is going to focus. So this NEP is part of the Biden administration's program to focus on COVID. They put out this guidance document. They announced it the day after their inaugural. They put it out a few weeks thereafter. The NEP was published on March 12th. Let's go to the next slide for the big one. The big thing that is going to come out of this is this emergency temporary standard. What this is, the emergency temporary standard is the authority that OSHA has, going back to the OSHA Act about 40, 50 years ago, but it allows OSHA to publish a regulation that's effective immediately. This is a little used sort of emergency process that OSHA has, but OSHA can publish a regulation. It's effective immediately, but they also have to, at the same time, publish what they call a notice of comment rule. So then they have to solicit comments from stakeholders and employers. I mean, anybody can submit a comment during that process, but the emergency temporary standard, or ETS, will be effective immediately, and that imposes mandatory requirements on employers, similar to what I suspect is going to be outlined in the guidance that we've already talked about. But there may be some additional requirements under the emergency temporary standard. OSHA, the Biden administration announced, as you can see here on the top bullet, this was coming, and it was supposed to be published this week. They're running behind from what we understand, and we've been monitoring it with some other colleagues here at the firm to see and it has to go through a lot of clearance within the administration, OMB, and some other agencies, but it will be published probably in the next couple of weeks. And it's basically going to require a mandatory COVID-19 plan, an assessment plan, and for employers to take appropriate steps on social distancing, PPE, masks, plexiglass, and other things. It's all going to depend on your work site. And the other thing to mention, and then I'll turn it back over, I think, to Annie next, is several states have already published an emergency temporary standard. Some of the state plan states like California have, and Michigan and a few others have, and actually, interestingly, Virginia. But this federal OSHA one will cover the whole country, and I think will be much more impactful. So this is going to be a big initiative for employers to watch out for. And so now I'll turn it back. I actually turn it back over to Claire to talk a little bit about COVID and the EEOC.
Yeah, and John, just so that we're all clear, the OSHA standards, when they come out, that'll apply to all businesses. It won't be limited to certain types of businesses, right? That's what we anticipate.
Right. That's a great question. And yes, it'll be affect all businesses, all employers.
Got it. Thank you. So the EEOC, like OSHA, has also been playing a critical role in providing technical assistance to employers about how to navigate the COVID-19 pandemic without running afoul of our employment civil rights laws, including the Americans with Disabilities Act, GINA, Title VII, and the ADEA, which prohibits age discrimination. For those of you who are not familiar with it, the EEOC has been putting out really extremely helpful guidance in the form of what they are calling a what you should know document. This is a series of FAQs that are regularly updated, and they address topics such as disability-related inquiries, confidentiality, medical information, reasonable accommodations, return to work issues, and the like. So we've been monitoring that and providing updates, but we would recommend that all of you check that out as well, because it is very helpful. Next slide. And of course, the most pressing issue for employers right now is what to do with respect to vaccines. It's certainly the area that we've been spending the most time counseling on lately. The EEOC has issued some helpful guidance already. So for example, one piece of guidance that they put out at the end of the year was that there is nothing in the civil rights statutes that precludes an employer from mandating vaccines, as long as the employer also provides reasonable accommodations for people with disabilities and those with religious objections. So I think that question, and Annie and John, I'm sure that you've been getting this a lot too, is the single most question that we've been asked recently is, can we require our employees to be vaccinated? And the answer, according to the EEOC right now, is yes, as long as you're accommodating people with disabilities or people with religious accommodations that seek a religious accommodation because they have a religious objection to vaccines. The EEOC has also pointed out, and this is a little bit contradictory, they've also pointed out that an employer may only exclude an unvaccinated individual from the workplace if that individual poses a direct threat that cannot be mitigated by reasonable accommodations. And so that direct threat analysis is individualized, and it requires employers who are considering an employee who is refusing to be vaccinated, whether that person, there are other steps that can be taken besides precluding them from coming to the office that would mitigate the risk that they pose to fellow employees and others entering the office, such as masks, face shields, closed offices, things like that. The EEOC has also made clear that asking about vaccination status is not a disability-related inquiry. So employers are free to ask their employees whether they have been vaccinated. But, and again, it's, everything, there's a catch. So you can ask your employees whether they've been vaccinated, but you shouldn't ask the follow-up question if they say no. So you don't want to ask why a person has chosen not to be vaccinated if the answer that you receive is no, I'm not vaccinated, because that question about why could be a disability-related inquiry subject to EEO guidelines. One area that we need more guidance from the EEOC, though, is whether and to what extent inquiries by third-party vendors who are hired by employers to provide the vaccine. So, you bring a vendor on site to administer the vaccine to your employees, whether those individuals are considered agents of the employer for purposes of that ADA disability analysis. Because if the answer to that is yes, the pre-screening questions that the employee must answer before getting vaccinated will constitute a disability-related inquiry, and in turn, that can impact the amount of incentives that an employer can provide. So this issue is pretty complicated, and there are a number of business groups, over 40 business groups, that have asked the EEOC for more guidance on this specific issue. So we anticipate that we're going to see more guidance here. We just don't know when. So there are also wage and hour issues that are implicated by the vaccine. So I will turn it back over to Anne.
And just before I get to that, I just wanted to stress to everyone, I mean, we've talked about the OSHA'S, the rule that we expect, and the fact that it's going to hit every single company. We anticipate people will, for example, have to wear masks in the workplace once that's passed. It's really unprecedented. What OSHA has done in the past is have this general safety type provision and gone in and enforced that. So to impose like a precise rule on what safety means in your particular workplace, stay tuned. But at this point in time, you are the best decision makers in terms of what's best for your workplace in terms of safety, and how far people should be distanced, and whether windows should be open, whether customers should be accommodated outside for returns if you are in a retail establishment. And those are things that you should start thinking about now, because there's going to come a time, I believe very strongly, that you're going to have plans and all of this in place. So it's a good idea to start thinking about that. And while Claire talked about vaccines and forcing vaccines or imposing vaccines on your employees with a couple of limited exceptions, the same thing is true of masks. So if there's a question, and it doesn't matter whether someone's vaccinated or not, wearing a mask in the workplace, as was said earlier, is a very wise thing to do. Also, if it's a retail or service establishment or customer facing establishment, to require masks is probably going to happen anyway, and it's a really good idea. We're already seeing litigation stemming out of that, including like a wrongful death case where masks were like not only not pushed on employees, but also arguably prohibited. Some anti-maskers running an organization didn't want masks, and now there's a wrongful death suit that came out of that. We're also seeing lawsuits and threatened lawsuits based on people refusing to wear masks and then suing, saying that they have a disability. There's a safety defense to that, and it's been backed by federal agencies already. So I do not think that should be a concern for anyone. We need to be a lot more concerned about getting people sick because we're not enforcing the masks. So
Annie,
yes.
If an employee refuses to wear a mask and there's no ADA or no religious restriction, can the employee be terminated?
The employee you could tell the employee that they are not permitted to come to work without a mask. Absolutely. And absent you having a workplace where you do accommodate regularly people working from home, that doesn't necessarily have to be an accommodation either. Working from home is generally not an accommodation pre-COVID for most employers. So that's not something that post-COVID you would necessarily have to do. It would be sort of an extreme circumstance, but you can absolutely require that anyone entering your private workplace or your retail or service establishment wear a mask. And that's true for cars too. If someone's a driver, you can absolutely require a mask and you have a safety defense, regardless of whether they have asthma, COPD, emphysema, all of the things that we've heard people say, I can't wear a mask because of these reasons, and it's a customer, look to accommodate them outside, look for an alternative, but you do not have to allow people because they are, just because they are disabled doesn't mean that they can expose people to something that could kill them, is effectively the defense to that. And I really don't think anyone's going to lose those cases. So
That's right.
Sorry, go ahead.
I was just going to say that's consistent, Annie, with what you're saying with OSHA guidance on those same issues of taking steps to preclude employees from being in the workplace without masks. OSHA is not going to investigate if somebody files a whistleblower complaint after getting fired for refusing to wear a mask. It's just not going to happen based on their focus on the encouraging mask wearing and probably mandating it here in a couple of weeks.
Is the employer required to provide the face coverings or the PPE, or can they require the employee to bring their own?
Under OSHA has a regulation right now that's been in effect for at least 10 years that requires all employers to provide personal protective equipment to employees that are necessary for the job. And again, that typically falls in a manufacturing type setting, but in healthcare and everything else. So that's pretty a standard OSHA requirement. And I think based on their guidance they've issued the last year in response to the pandemic, OSHA's consistently said that is an obligation. So in answer to the question, Nancy, and it's a great one, is that employers should provide or obligated to provide masks. And I believe that's going to be enforced in this national emphasis program I mentioned earlier.
Thank you.
And now that they're very accessible, it shouldn't be a problem. They're extremely accessible on Amazon and everywhere else. You just need the surgical one. It's a better idea to wear 2 of those, or a KN95 or a 95, one that's a 95 mask. So on the wage and hour issues, before I get to some of those listed here, paying for screening. So a lot of us are having temperature screenings at our workplace, sometimes for the public. We see them a lot in healthcare facilities. But if you're an employee and you are standing in line to be screened, do you have to be paid for that? And that really depends on where you are and what regulation is applicable. A lot of companies, however, for their employees, because this only takes a minute or 2 and they don't want to deal with some wage and hour case based on that. And California would be the most concerning to me because of the laws there. But in terms of paying for screening, having someone clock in prior to you taking their temperature is a good idea. Having them fill out the forms after they're on the clock, it will just avoid a headache. Ultimately, I do not think it would be a de minimis, which means just a few minutes, and just a few minutes is generally not a problem, except in states that don't recognize de minimis, and that's like a state like California. So, pay attention if you're screening, if you can actually have them clock in before that happens, that's a really good idea. Another thing, and Claire mentioned it earlier, is giving incentive payments for people who have vaccines, or even we have some companies that have chosen to say, your schedule is 9 to 5 at 9 in the morning, go ahead, and I know you're getting a vaccine, we'll pay for your time from the time that you leave your house to go get the vaccine. There's various types of incentives that are being offered to employees to encourage them to get the vaccine, because most don't want to force it, they would rather incent it, and are hopeful that that will work for a big part of the population. I think that, we'll shake that tree soon and see how many are going to be anti-vaccine. But we're not even near that right now, because we still have lines around the blocks trying to get vaccines, and people who don't even qualify yet. So, but stay tuned for that, because we do expect to see a lot in that space, including, I think, as Claire mentioned, the incentives for getting a vaccine, and whether you have to add that back into the regular rate for purposes of calculating overtime, which means it's treated like a form of compensation. We are hoping to see that there will be an exemption for that, since everybody wants to encourage vaccines. The last thing you should do is make it more expensive for an employer to incent the getting of vaccines. So we're hoping to see something in that space. Everyone was very, sorry, go ahead.
And just one point to add to that, Annie, there are some states and localities that are requiring employers to provide paid time off in order to allow employees to get the vaccine. Most recently, New York actually is requiring at least 4 hours for each shot. So if you have to get 2 shots, it's 8 hours of paid time out to be vaccinated. And Illinois has a similar rule as well.
Yeah, and a lot of companies are choosing, especially if they have operations in those jurisdictions, to just match those jurisdictions for their other employees. So there's sort of equal treatment across the board. And 4 hours does generally incent hourly workers, at least, for getting the vaccine. And ultimately, I think that's what most want to happen. So the independent contractor rule, everyone was really excited about the independent contractor rule and the joint employer rule because they are very company friendly and actually really pinpoint the things that you want to pay attention to in terms of whether someone's an independent contractor or they're not. And these are economics realities tests, you know, whether this person is really controlled. Both of these, the joint employer and the independent contractor rule, are a lot the same, very simplified rules that are out there. The Department of Labor has now delayed the effective date of the independent contractor rule from March 8th until May. And the DOL has published a proposed rule to just basically rescind altogether the independent contractor simplified rule. And there are comments due on April 11th on the proposed rescission, whether to keep the rule or not to keep the rule. So stay tuned on that. The joint employer rule, same thing. Comments are due on April 11th on whether to whether the DOL is going to withdraw this, but they have also said that they're going to rescind the rule. So comments on whether they should rescind that rule are also expected to be published sometimes near the end of April. There are a lot of opinion letters being withdrawn. So the opinion letters come from the agency, from the Department of Labor. Basically, when there's not a case on something or there's not definitive law, the Department of Labor at times, and generally during Republican administrations in the last 15 years or so, there were no opinion letters under in the Obama administration. We don't expect to see any, if any, opinion letters during this administration. And what we expect instead is that some of the opinion letters that were issued during the Trump administration, including on tipped workers, independent contractors, and truck drivers sleeping in their berths, we expect that those were withdrawn, and we expect that there could be others that are withdrawn as well. And all of these are made economic sense for companies. For example, the tipping is whether you could have a tip pool with hostesses along with other tipped workers who are servers, and that's now withdrawn. The independent contractor rule and sleeping berths, and a lot of those are because they deal with the independent contractor rule that has now been delayed and is not enacted. So they sort of they rely on that rule. So those are withdrawn. We don't expect to see very many, if at all, again, on opinion letters. And then the paid program is withdrawn. And this is actually a very good program for employers. And it's one that existed prior to the Obama administration and many, many years prior to that. And that was if you had a wage and hour violation and say you paid an entire call center wrong, you know, or you were rounding and it was unfavorable, it would allow you to go to the Department of Labor and say, hey, we made a mistake in our paying and it affects, you know, 400 employees. We want to fix that mistake, pay everyone back. And the agency would allow you to go self-audit, look at what was owed, and then basically pay out and get a release for those types of claims. The plaintiff's bar in this space doesn't like the paid program at all. And again, it was not used in the Obama administration, and it is withdrawn now. We don't expect it to come back in the Biden administration at all. I think that the plaintiff's bar and everyone else will be just enforcing the laws as they have before in the Department of Labor. The $15 minimum wage we've heard about forever. The American Rescue Plan, as all of you probably heard, did not include the minimum wage despite the battle to try to get that. The Raise the Wage Act is out there to continue to attempt. And then you have the federal contractors and what I was saying earlier about greasing the skids. If you can't get it done for all employers and private companies, the government often will turn to require federal contractors who are getting business from them to have this $15 minimum wage. We do expect to see this. COVID vaccine incentives, I already spoke about a little bit. And then there's the paid time for leave. The Family Act is before Congress right now. And we expect some activity on that. There's been a lot of talk about it. And the American Rescue Plan, that is the plan that extends tax credit for those who allow folks who are required to allow folks to take time off for being sick, and that's with COVID. So employers who are under 500 are required to give this time off. And if you are under 50 employees, you can seek an exemption for that. But that has been extended through September 2021, that you can get tax credits for providing that paid time off to employees.
Is that for just employers with 50 and under employees, Annie?
No, 500 and under. But if you have 50 and under, and it's like a hardship, you can actually apply to get an exemption when it's under 50.
Okay.
And so with that, we wrap it up and invite you to use the chat and ask any questions that you have for the next couple of minutes if you'd like to ask a question. If not, Nance, we'll turn it back to you to wrap us up.
Okay, I don't see any questions coming in. That was a lot of information, and it was a lot of informative information in an ever-changing landscape right now in a very different formats. But we appreciate everybody's time today. Thank you for your involvement in joining us and spending some time with us today. And we look forward to seeing you at our next broadcast.